Good morning, everybody. That's a little loud. Sorry. There we go. So yeah, Steve and I talked about how best to present the overall subject of land, because there's so many different types of land. Land opportunities, both as investors, listing agents, buyers. And we can't do it all in one day, so this is primarily about the paperwork. And for those that are outside of the NVAR part of our geographic area, just follow along, because the same principles will apply with your paperwork, whether it's G-CAR or MAR or down in Richmond. Doesn't really matter. The fundamental concepts are all the same, but we will be following up with, so as Steve said, this is mostly about the listing agreement, the NVAR exclusive right to sell unimproved land today, and some talking points, some fundamentals need to know from a listing agent standpoint, and pricing and highest and best use for the property, that kind of thing. Next week will be on the contract document and more of a focus on being a buyer agent. But we're going to follow it up with an overdue, more in-depth class with an engineer, a local land engineer that I know, a good guy. We'll make reference to him today, but that we hope to have within the next month or so. So stay tuned for that one as well.
All right, so pulling up the exclusive right to sell unimproved land, which is should be slide number 3 on your thing. Might be hard to read, but if you need to pull them up, you can always pull these up on your own. But it's just a standard land exclusive right to sell unimproved land. Now the one thing about these NVAR contracts, right, is they're all pretty much standard on the top part, right, between a buyer and the seller and the firm name, right? So the one thing on this contract that I kind of circled was the seller, right? And the reason being is because in today's atmosphere, believe it or not, there's a lot of fraud going on in regards to sellers and land. So one of the things that we wanted to talk about, first off, you get that call or you get that email, most of the time you're going to, say you get that email, what are the things that you want to do in order to prepare yourself for a potential land listing? And the first part really is you want to verify that seller. And there's ways that you can do that, right? To verify who that seller is and make sure that seller is not misleading you in a direction that could be a fraudulent listing for you. So the first part of it is, where did this lead come from? Okay, if it's a phone call, if it's someone calling you directly, a referral, those kind of things, the worry factor decreases quite a bit, right? But a lot of the ones that we know that are fraudulent come via the internet. Someone reaches out, says they got your name and number they got your name from someone, and they have a piece of land and they want to sell it quickly. They have some sort of family emergency, they need the cash, they're willing to sell it quickly, and they want to list it as quickly as possible, and they want to get things going very quickly. Things you can do once you receive that email is, in your response, is you can respond in regards to points that you need to make in order to actually move forward with a prosperous listing, i.e., you want to schedule an actual call or a video conference call, or you want some sort of identification to be provided so that you know you're dealing with the right person, right? And so I've listed some of these things in here in regards to that. Is, where did the lead come from? All right, it's an internet lead. Did you actually meet the seller? Well, if you actually met the seller and everything was cool, then you're good to go. Keep going. Now, if you get to email leads, right, verify, get identification, set up face-to-face via Zoom or FaceTime or whatever type of electronic pathway you might have in order to chat with the person on the other side. You can also Google information on the seller. Find out. Sometimes you'll find that like I think we had one time where the seller actually lived in Denver, right? but the people that were communicating from somewhere like in South Africa or something like that. So I mean, there's warning flags out there when you're trying to vet who the seller is.
You guys may say, I've never heard of that, or that would never happen to me. But we're bringing it up because it actually, over the last four years or so, specifically, for some reason, I don't know if it was part of the COVID situation or not, but we saw a real increase in it. And some of our Sampson agents, fellow agents, have been suckered into taking listings, in a couple of cases, actually getting ratified contracts on these listings as well, with a seller they've never met, and it turns out to be a criminal. We had the FBI in here 2 years ago or so, a couple of FBI agents, special agents, to talk about wire fraud, but also about this subject. So no matter what listing, I mean, it's not just land, but any listing, know who you're dealing with, and these leads do come in cold from out of state and sometimes out of country sellers, and so we want to know, as Steve said, do a video conference and get ID from them.
Right. Well, and some of the early warning signs too for those type of fraudulent land listings are, they want to sell below market value. They want to sell as quickly as possible. They don't want you to put a sign up on the property. There's certain telltale signs when you're going through this. They can't meet in person for whatever reason. We've had agents that'll perpetually reach out to the client and say, hey, I'd like to set up a video conference call with you in order to discuss this, further. And they always have reasons why they can't video conference. They'll just because you get ID sometime doesn't necessarily mean it's on the up and out.
We've seen completely counterfeit driver's licenses and passports. So any questions on any of that stuff, reach out before you move forward with putting the listing on the market.
Well, if you do encounter fraud, right, because we get a lot where people do encounter it, there's avenues that you can do as an agent to report it. One of them, and I pulled this off of the Virginia Association of Realtors website. They have a whole thing on being scammed in regards to land. If you want on your leisure, it's part of this presentation. It'll be on the Nest, that kind of stuff. But as you can see on here, don't fall victim to vacant land scams. They have a whole article here on protecting yourself as a selling agent in regards to listing land. So keep that in mind. There's also, each county has their own fraud protection line. So whatever county you're in for whatever that transaction may have occurred, you can also contact that. You can go through that county's website and report it. And you can also, I've seen a lot of people post stuff on Facebook, right? On the Sampson agent page in Facebook. Because recently I saw one in Fredericksburg area where several agents, the same piece of property, like one agent would turn it down for whatever reason because they suspected it was fraudulent, and they were reaching out to another agent, and it was only by chance that they saw the agent had posted it in the Sampson agent page. They said, hey, that sounds very similar to what I'm going through now, and they were able to figure out it was the same scam. So as far as next paragraph is your property, make sure you get as much information as you can regarding the property and fill it in on paragraph 2. In here you can, sometimes you'll have instances where you'll have multiple parcels that the seller may want to convey at the same time. You could theoretically do one listing agreement for multiple parcels, just outline those tax IDs, especially if they're all being sold at one price. If they're breaking them up into separate parcels, you may want to do individual listing agreements. But if they're selling, like, say, 2 or 3 parcels all together at one fee, you could potentially do them all up on one listing agreement, just outline those specific properties on your listing agreement.
Right.
Property considerations. So some things to think about when you're meeting and talking with the seller in regards to property considerations for that. So remember, all types of properties, land opportunities for realtors, urban, suburban, rural, small parcels, blah, blah, blah. So it goes through all kinds of stuff. This is mainly focused on residential, but it could be commercial, any type of land, right? Do you have the precise legal description with tax ID? Some rural areas may not have that, right? So you may have meets and bounds, that type of stuff, or an old survey, that may be the piece of evidence or whatever that you'll need in order to make sure that you know what piece of land that you're selling. Will more than one parcel convey? If so, make sure, like I said, you can do that all on one listing agreement. Other things that you might want to look at are there easements, other things on the property. Hopefully the seller has some sort of survey or something that they can give you information, or you may want to do that as part of your pre-listing information. You may want to have the seller, or as your listing package, order an appraisal of that or a survey of that property so that you know exactly what you're dealing with.
Right. Yeah, if you're going to list land, that's definitely one of the things that you would like to have is a fundamental plat at a minimum. And plats are different technically than like a house location survey or a boundary survey. A plat is typically from the original subdivision, the declaration, when that lot was created, and it's usually in the land records, in the title report. So if the seller doesn't have it, it might be obtainable through county records or with a title search. But knowing what you have and ideally having the boundaries marked, is fundamental to the best interest of your seller. But it's not your job to incur expense over that. But always ask right up front, what do you have? What does the seller have in terms of anything to do with surveys, easements, rights of ways, that kind of thing.
Right. Another thing that you'll have to be aware of too is environmentally sensitive areas on properties, right? Part of the Chesapeake Bay Protection Act, those type of things, and those hopefully would be denoted in any type of plat work that you might get. There's a lot of information regarding protected areas associated with the Chesapeake Bay Act, and I put a website in here, or Mike, part of Mike's outline provided a website where you can get additional information overlays on where you might see the Chesapeake Bay Protection Act avenues applied.
And by the way, we'll close with this as well, but I wanted to let you know that later today, we're going to have a document in the Nest called Listing and Selling Land Fundamentals, which is there's going to be 2 documents up there. And one of them is a multi-page outline of these talking points and some additional talking points. Food for thought, real things for you to consider as a listing agent or a buyer agent. The outline itself will be in the Nest, as well as a binder to include a lot of additional documents. But this is the document that has live links, so you'll be able to go to the Nest, click on these links to go to see examples. Most of the examples that we've used are for Fairfax County or Loudoun County, but the vast majority of our local counties here have a lot of great resources online. When you get further down south or out into the hinterlands, you're not going to have as much of those resources immediately available online, but really good, valuable information for you to be able to get at your fingertips when you're looking to list a property. So be aware of that. We'll close with a reminder of this.
So I mean, that's one thing you're looking at as your listing agent, right? You're looking at protection, water protection type things on the property. The other thing that you potentially have to watch out for too is the potential for special use permits or rollback taxes on properties that someone might be using a property, say for agriculture, and they're doing that in a way that forgoes some of the taxes that may be applied to that property. Well, if you're listing the property and you're going to market it to other type of venues, then who's going to pay those?
You need to know.
Yeah, who's going to pay?
Sometimes it's referred to as land use. You'll hear that term, land use. It's a preferred discounted rate on the tax rate. As Steve said, it's usually relating to farm, agricultural, farmettes, or livestock issues, but also it could be timber, it could be Christmas tree farm, whatever. And there's surprisingly a lot of those out here, these wineries, all kinds of stuff. So basically, we have links in here that go to county websites for examples, what you need to know.
Right.
And then we'll leave it at that.
And those are questions that you'd want to be talking with the seller about, right? When you're talking, how are they using the property? Are they, what type of taxes are they paying? Are they getting any breaks on those taxes? If so, you don't want to ratify a contract as the listing agent, only to find out as you get closer to the end of the deal, the buyer finds out that there's some taxes that are going to have to be paid because they're going to use the property for something different than what it's currently being used for. And someone's may have to pay those taxes. Now,
and there's an annual application, I believe, in most of the counties, even for sellers who currently qualify. They have to renew their qualification annually, and sometimes they forget to do that. So.
And then, and I think I made a note in here too on the last page that those tax deferreds may apply up to 5 years prior to the sale. So it could be 5 years worth of taxes coming due if the person that's buying the property is going to use it for something different, right?
And the standard contract, when we get to that page, it speaks to this.
Yeah.
It says who's going to be, is the property subject to rollback taxes, yes or no? And if so, who's paying for them? Who's responsible for it?
Any questions so far? Excellent job, man.
All right.
You're doing a good job then.
Thank you, man.
Next part of this listing agreement is the agreement terms and listing terms, right? Just covering this briefly because we all know this changed back on July 1st, right? So the first part is the agreement term. When does that expire? How much time do you need for land, right? Would a standard 90-day agreement work for land? I mean, depending on what type of expenses you may be incurring in order to get this land ready for the market. So you may want to go with a longer time period, depending on the parcel, depending on what the other properties in the area may be, time frames that they may be selling on, right? Sometimes these properties are on the market for years, right? So make sure you do your list.
If your seller's looking for highest and best use that might not be a by right use right now, but is conceivable, it's plausible under the comprehensive plan to get a subdivision or some type of rezoning or special use, all of that takes time and money. So.
Yep. And then as the additional language on here regarding the listing term, when is that date going to be that you're going to actually start marketing that property? So are you going to start marketing that property right away? That would be the date that would go in there. If you're signing this in and you're going to do a bunch of work beforehand in order to get it ready for market, i.e., survey, studies, whatever, make sure you put a date in there that might be in the future so that you have enough time to do that, right?
And this language, like most of the language in this document, is basically identical to the NVAR exclusive right to sell residential improved, standard listing. So we're not going to go into as much depth as we might otherwise because most of you are familiar with the standard listing agreement, right?
Yeah. Are we good with it? We all know how the listing term works, right?
Yeah.
Right. So, because we get a lot of questions regarding that recently, right? The old way was you had to have the bright MLS disclosure, exclusive listing signed within 2 days of having your agreement signed. It didn't matter, right? Then effective July 1st, now they have the listing term date in your contract, in your agreement, and whatever that date is within, as it says here in here as well, is you have to have within 2 days, it has to be in the MLS as coming soon, active, or an office exclusive from that date, right? So we're all good with that. All right, list price. So now we have to determine how to figure out the list price for this property that we're looking at. There's factors that go into that, right? I mean, it could be based on an overall price for the whole property. You could do it on acreage or square footage. However it's deemed you and the seller want to best pursue that. Now, we did put some notes in here, determine the best list price. What's the current zoning? Is that going to come into play in regards to determining the list price? I mean, if you're in an area that has a bunch of residential lots and you're looking at a agricultural lot, you may or may not get the same price, right? Or higher, lower, what? So those are, these are some of the things that you would have to consider in regards to determining your list price. Is there a realistic potential for upzoning? Highest density residential, commercial, etc. Are there possibilities with this lot? Is it subdividable? All good questions, right? What could the property be used for? Residential, multifamily, commercial, industrial, farming?
Quasi-governmental. There's a lot of church applications, adult daycare, child daycare. There's these what they call quasi-commercial uses that require special use permit approvals, but they can sometimes be obtained under standard residential zoning without any rezoning. Okay, that's why you see them all over the place. These little facilities that are tucked right in, adjacent to residential communities.
Right.
But they can bring higher value, right? It's different use equals potentially higher value. So always get familiar with the zoning ordinance in your subject property county. You go to the public record, your tax record first, of course. Look at what it says there and I would always recommend for any listing cross-referencing what you see in the Bright MLS tax record versus what is in the county tax record. Because what's in the county tax record is more official and more current. Sometimes there may have been changes. It usually wouldn't be a change to the use, but
it's more detailed too.
I'd rely on
the county. The county documents are a lot more detailed than what you get through MLS. So,
but it shows the existing zoning classification right in there. Everybody should know that. And with that existing, if it's R1, R2, B1, C1, the different classifications, you can quickly go online and look that up in the county zoning ordinance and see what alternative special uses are possible if that's of interest to your client. We're not engineers, we're not zoning attorneys. We don't want to give our client unrealistic expectations, but it's our job to do fundamental evaluation to understand what the comprehensive plan calls for any upzoning, higher density, or change in use, that kind of thing. So easy information to get online, or I always recommend to people just go into the county. Go into the county with your client or yourself. It's a great learning experience. Meet the county staff. This is the zoning staff, the planning and development office staff, the health department, environmental health department people, if you're looking at septic systems particularly. Their job is to help you, and we taxpayers pay their salaries, so you can either call and get an appointment with an engineer of the day, or you can, in a lot of cases, just walk in. I would always call ahead to see what their protocols are. But really, and it shows your seller that you're going the extra mile within certain limits. And beyond that, if they have it in their brain that they can subdivide or rezone or whatever, then we would probably recommend that they consider a feasibility study with an engineering firm and or talk to a zoning attorney. Because what you don't want with these land listings is to have something that is way overpriced because of the what ifs, the speculation of what future value might be. There is some of that, if it's real, if there is subdivision potential or rezoning potential, that translates into value incrementally, but you got to be able to back it up. There's no comparison to the incremental value increase with having it done, like a completed subdivision, recorded, platted subdivision, or a rezoning. But information's power, and it can really help your seller by having as much of that back up and uploaded into your listing, your Bright MLS listing docs section.
Right. Another thing too that's going to potentially change or add value for your property is especially in the residential and around here, say in Northern Virginia, is residential lots, right? Is the residential lot, are you partnered up with a builder who wants to build to suit, right? So are you marketing the land with the potential for a property? So if that is the case, then you would probably have all the information from that builder in regards to the drawing and potential how that would lay out on the property as part of your package for listing the property, right?
Yeah, you all have probably seen examples of that out there. It could be infill lots locally, or it could be property that's more rural, where you might see a builder's sign on the property in addition to the listing agent's sign. That doesn't mean that the builder owns the land, because they typically don't. But I have a document that I wrote some years ago, which is also available in the Nest, and it'll be part of this package, this binder that we'll have in the Nest today. And it's called Contract Build Joint Marketing and Commission Agreement. So, sometimes you have a lot and you've had it on the market and it's not getting the attention that you want, and you can talk to your seller. You can do this right out of the gates with the seller, or if it hasn't been moving, it's sitting there. Well, maybe you need to draw new eyes on it by having a builder that can put a rendering of a home, right? A big sign, perhaps. Doesn't matter really how big it is, but you could have, we will build this home for you on this lot, or build your dream home on this lot. We have other floor plans available. And, because your commission on the sale of the lot as a listing agent might not be all that much, but if you could also secure a commission on a new home construction contract value, that changes things big time, right? And it doesn't need, it can be an arrangement with a builder. Obviously, you would want to only do it with a builder that's reputable, that you as the listing agent are aware of, or they convince you of the quality of their work and all of that. But by doing it, there's no obligation for any buyer of that lot that they're going to necessarily build a home with that builder. It's just marketing. But it can help.
Yep. And then some ways to determine pricing, right? As you're trying to determine the pricing, I put some resources in here for determining that. There's surely comps in the MLS. You can also, if you're subscribers to CoStar or LoopNet, those may have some more of the commercial land type stuff in it for you. Also, there's a website that we posted here as well. landandfarm.com has a lot of different listings that are more agricultural land type stuff.
Right.
Any others you can think of offhand?
The underlying issue is that with lots, there's often not a whole lot of comps,
right?
Or direct comps, right? It's one thing if you're in town of Vienna or Falls Church or Arlington or some close-in area where there's plenty of teardowns. That's been so common, and it's an infill lot. Utilities are already there. Zoning's in place. That's really simple when it comes to land, and it's easier to price those, of course. But when you don't have as many comps, if it's residential, for example, what I recommend is that you you try to determine, first of all, is it one dwelling that you're talking about or more than one? And what is new construction pricing going for? What's the maximum range of a new home, completed new home sale in that immediate area? You know, is it $1.5 million? Is it $2 million? Or is it lower than that? Because that can also, it's part of the overall analysis of putting a fair price on land is what's the maximum percentage that the typical buyer in our marketplace will pay given a new home, if it's residential, a new home being built there. Will they pay, it used to be, for years and years, it seemed to be that, so builders would not want to pay more than 30%, 25, 30% for the land of what their projected final new home sale price delivered would be. Well, that's a builder because the builder has to build in profit, right? So there's a big difference between what a builder will pay versus what a homeowner will pay for that land when they've concluded that's where they really want to be, you know, and they can envision their dream home on that lot. They're more emotional, they're invested, so they may pay up to like 50% of the future value of the home that they want to build and what would appraise, you know, that they can finance or whatever. That's pushing the envelope, but we see it in our market because land is so scarce and because people around here have money. A lot of people have a lot of money and they pay cash, whatever, so they'll pay top dollar for some of these lots.
Yeah, and other factors that go into that as well is what's the location of utilities to the lot that you're looking at? Is it going to be relatively expensive to bring in utilities, or are utilities close by, or even in some cases on the property already?
Right.
Now, if you have a property you're looking at theoretically with a tear down, would you use this contract, or would you use the normal?
That's a good question. We get that a lot. If your buyer is going to buy property that has structures on it, whether they are still livable or whether they're totally dilapidated, should you use the residential sales contract or should you use this? In my opinion, and what I recommend to agents is if your buyer is absolutely going to tear that dwelling down or whatever structures are there, I would use this sales contract for unimproved land, but then there's a section that's chattels and equipment or in additional information. You would say that the existing structures, the existing dwelling, barn, what have you, detached garage, convey as is, right? You want to state that they're there on the property, but it doesn't mean that you need to use the residential sales contract. And if it's an older house, you should still use the lead-based paint form, okay, even if you're using this sales contract for unimproved land. Why do I say that?
On the listing agreement side, would it not matter?
No.
Okay.
You're right.
No, I was just curious.
Give me the hook right there. We'll talk about that next week. We talk about.
I'm just curious. I'm just asking questions. I'm asking questions.
Listing agreement. Yeah.
No, that was just a question I was asking. So on the listing side, it wouldn't matter if you use this contract or if it did have a parcel on it, it wouldn't matter if you use this agreement or the
that's right.
Or the residential or exclusive right to sell listing agreement, either or.
That's right. Oh, of course. Now I get you. I'm sorry.
That's okay.
So
I'm still early.
I would still use this.
Okay.
This one, unimproved land listing agreement. Right. If that's the way it's being sold.
Right. Yeah. If it's a tear down or
right.
or the outbuildings are trash and they're most likely going to be bulldozed down.
I mean, the seller doesn't care if somebody wants to, and that is very common with listings and your pricing evaluation with homes they're livable, right? They're older, they're livable, they need complete renovation. And there's a lot of buyers around here who can't necessarily afford a new home, a brand new home, but they can afford that, and willing to roll up their sleeves and do some work themselves. But trying to find that sweet spot is what's top dollar. Is top dollar more as a tear down with, you know, the future value of a new home being built on it, or is it about even with buyers who will buy it? Some buyers will pay top dollar to move in, even though others will tear it down and build new. So it's all part of the evaluation on price.
You had a question? Hold on.
I still don't get clearly understand if we are listing as is, even the structures in there, and land only, they use listing as a land, then I don't have to have lead-based paint.
No, I would have it, is what I said.
Oh.
There's
so
a structure on the property, and it's built before 1978. Use the form.
Even if it's a land, sell as a land.
Yeah.
Okay.
So other factors that might come into play too in regards to pricing out a potential land spot is whether or not the property is cleared, right? So if it's fully wooded, it could be a lower price versus maybe they already started clearing it for potential building of a structure, that kind of stuff. So that could vary in regards to your pricing as well. Mike already talked briefly on formal highest and best use for feasibility studies in regards to potential pricing for land as well.
And by the way, in the package that's going to be in the nest, I've got an example, a real-world example of a feasibility study, multi-page, that was put together by a local engineer on a deal that I did in Vienna. Simple subdivision, but it's just one example of a land development consultant report. And in certain circumstances, you might want to recommend to your seller, like I did some years ago in this case, because there was real potential for subdivision. There were some constraints, as there usually are. It's never quite as easy or cookie cutter as people think it should be, but because the potential was there, I talked the seller into paying for boundary survey, topo survey, perk tests, and an actual feasibility study for highest and best use, and doing some layouts, some engineered lot layout, the most logical layouts, and in this case it included a road going in with there's only three additional lots, and identifying where the approved perk sites would be, so identifying where the most ideal home sites would be. And we never intended to take it all the way through subdivision approval process, or it was never it was an estate sale, and the intent was never to become a developer or builder and create finished lots to sell as finished lots. There's money in that, but it takes money. Got to pay to play to do all that.
What are the costs, expenses on stuff like that?
Well, so in the information that you'll be able to see in the nest, and in follow-up sessions, like I said, we're going to be doing a session with the same engineer that put this together. But in the nest, with part of this package, I do have real-world scope of services with pricing. I mean, this report itself was like $9,000. Some are more, some are less. And surveys can get pricey. The more land you have, I mean, it can get pricey. But the topo surveys, all these different studies that go into it speaks to what the county's going to require anyway.
So the report,
of anybody.
So the report itself was not, say, roughly $9,000. Did that count all the different surveys and stuff that you guys put into that as well?
Nope.
I mean, theoretically, I'm just curious. I mean, what would if you're talking to a seller and you want to discuss different options like looking at potential for subdividing, and you have to do perk testing and you have to do
perk testing is cheaper,
right? But if you're going to, and then you're going to do engineering, topography, soil sampling, all that kind of stuff. What does something like that run? I mean, I think your lot was what, 3 or 4
all
acres?
In, so this was a 4-acre lot. All in, My sellers paid 45 to 50,000 bucks. They did. But that included legal. We did take it all the way through to record plat approval. So it's not that much money in the big picture, but not everybody can afford it. But it is a gamble because there's no guarantees until you get final county approval. Land Development Services, LDS, is what in Fairfax County, that's what they call it. And, you know, it's very, very difficult for the typical property owner to do it themselves. You got to have an engineer.
How long did that take?
Longer than we wanted, but it was about 9 to 10 months. It did not involve any rezonings, take
Right.
longer. And we employed some, a little bit of legal, the land lawyers. Mark Lublai, our very own Mark Lublai in this company. His older brother, Mike Lublai, is one of the founders and principal attorneys with Walsh, Colucci, Lublai, and Walsh. They go by the land lawyers, and they're based in Prince William, but they do a lot of commercial, but they also do residential development. I worked directly with one of their attorneys for some of the contract work, but that's, you know, a lot of different components, but the main thing is just be aware that mostly perk tests, survey, and understanding about wetlands. Are there any wetlands on the property, any streams? Are there any ponds downhill from the property? Because all of that are red flags for potential RPA issues, Resource Protection Area, also known as ESA, Environmentally Sensitive Areas. They're kind of used, those two terms are often used interchangeably. I think RPA is more common. Some of them, not all of them, tie directly into the Chesapeake Bay Act, Watershed Act, with restrictions on development. So a lot of people think they've got plenty of land. They got plenty of land for subdivision, but because of some of these restrictions related to topography or poor soils, you know, not good perk, or these RPA issues, that can definitely limit what otherwise should be a by right candidate for subdivision. And one other issue is road frontage. You got to have certain minimum amount of road frontage for each lot whenever you subdivide. That's defined under each county's zoning ordinance. So when you look up R1, R2, R3, these different zonings, not only is it talking about how many, for residential, how many dwelling units per acre, but what's the required road frontage per approved lot. Like it's 150 feet required for R1 zoning, one dwelling unit per acre in Fairfax County. You got to have a minimum of 150 feet of road frontage. They don't like, and they don't approve pipe stems. A lot of the counties, I mean, it depends where you are, but the closer in counties, they're not liking pipe stems typically anymore. So they want dedicated ingress, egress for each proposed lot.
What did you just say about
Pipe stems are not approved like they used to be for new communities, very rare.
All right, we had a question over here.
I just wanted to know if you're going to include the liability waiver with your packet. You had done one for me when I had a,
You mean to enter at your own risk? That kind of thing?
you may recall, I had a property where it was a Civil War home.
Yeah.
And the town loved it. We sold it, but we held an open house because there was mold and everything in the house.
Yeah.
And Mike was great about doing a liability waiver for me so that anyone that went into the home entered at their own risk.
So I do have that document. I think it's in the Nest library. If anybody needs one, you're welcome to email me. This could be for any type of property, any type of structure, whether it's the house, the primary dwelling that is condemned, or there's no utilities on, or maybe there are utilities, but there's the risk of falling through the floor, or toxic chemicals or mold or whatever.
That'd be termites, right?
Or-
Falling through the floor.
Or a barn, dilapidated barn. So there are these documents which, if for risk management, we don't have a hard and fast company policy, requiring agents to use them, but basically what it says is before anybody is given access, you could have a combo box instead of a realtor lock box for something like that, where the buyer agent and the buyer have to sign this form and return it to you before you give them a code. Okay, that kind of thing. Good question.
Next part of this is the listing broker compensation on your form. Set up the same way as all your other NVAR forms. Talks about your listing brokerage compensation. So this would be your listing side. How much are you charging the seller to list this piece of property for them in regards to this transaction? Is it based off of the sale price, or is it a flat fee, or is it a percentage of the commission plus whatever maybe additional fees that you may have? And then how far after your listing agreement expires could you expect a compensation if the property did sell and they didn't sign up with another realtor? Then you have your additional brokerage compensation for unrepresented parties, right? So the way this agreement's set up, just like your exclusive right to sell listing agreement, if there's unrepresented parties that come forward, are you going to charge that seller any more money in order to do the paperwork and run that buyer through all the way to settlement? If so, you would fill in paragraph 6B.
I would highly recommend that you do,
Yes.
because there's going to be more work involved and more risk to you and to the company. So,
Are you offering variable rate compensation? If you are, you would write that in. And remember, if you are doing variable rate compensation, you are required to disclose that to any potential other buyer agents that are calling in on this property, right? For properties that may equate into why you're offering variable rate compensation.
CC.
I had land listing a long time ago, but now recently I didn't have it. Since we have changed the whole 9 yard. What is going rate for the listing side normally?
Going rate.
Yeah.
We're on the record with that, right? Right, Jeff?
I mean, it's a different than residential.
Our fixed rate, Samson Properties fixed rate commission. Let me answer that. Over the years, it was very typical to have
Right.
somewhat higher total compensation
Correct.
for land. And I would say that it still could certainly be often justified, but it depends. Every piece of land, every land listing is different. What's the marketability of it? What's the sellers, what do they have? Are they pie in the sky with their dreams of what it's worth, or somebody's told them that it could be commercial one day, all of that. Like any listing, whether it's a standard residential improved listing or land or commercial, if you and the seller are not seeing eye to eye based on your research and professional opinion, you got to decide whether you want that listing. But you also look at what's the average time on market. Time's money. So there is no standard. That's the answer.
Okay.
But you got to evaluate how much research. Like some of these projects where you're going the extra mile, be the professional that you know you can be or that you want to be. That involves a lot of research and time and trying to bring in your team of experts. We're not lawyers, we're not engineers, we're not tax attorneys or zoning attorneys, but we are the source of finding all that information for our client. It all takes time. So I would say err on the higher side whenever you can.
So early termination, right? This paragraph is set up for if the seller, you get the listing, you start putting time and effort into it, and then all of a sudden the seller decides to cancel their listing. You put 0 in here. You've just spent a bunch of money getting this listing ready for the market, whatever money you may have put in, and you put 0 in there. There's no recourse that we can help you with in regards to getting any type of money from that seller, right? Because you have put it in the contract that your early termination fee is 0. So make sure you fill these in with what you feel.
Or if you leave it blank.
Yeah, or blank.
If it's blank, or if you put 0 in it, you might as well consider that means 0. They want to terminate, that's it. They terminate, no questions asked, and you get nothing.
So make sure that you put an appropriate number in there, especially as you start to realize what costs you may have to spend up front. If the seller and you come with a plan and it involves you paying for stuff, right? Make sure that you have some sort of termination fee in there so that you get some, whatever money you put into it, right?
Your call, obviously.
Same as all your other listings, right? If you're doing blank or 0, you're allowing the seller to just void the contract and walk away with no penalty.
And with land, a lot of that might hinge on what your agreement is, what your conversation with the seller is as to who's going to do the extra research. Who's going to the county? Are they? Are you? I advocate for you to do it. You're the professional. Again, it's a learning experience. Every time you go to the county and talk to the different departments, staff, makes you a better agent all the way around. Because each purpose is unique and each property is unique. So when you do it for different properties, different clients, it's all good knowledge base. And it's free. That part's free. It's just your time.
Maggie, hold on.
Yep. Hey, Zach, maybe we should just leave some
I
mics
just
up
had
front.
one last year that it was debatable as to whether it was a tear down or it was going to be purchased by someone who was willing to redo it. And I called the county to find out some information about it. And whoever I got a hold of started telling me that they were trying to preserve that type of architecture and that they really wanted to know what was going on. So you got to be a little bit careful who you talk to at the county.
And it wasn't even in a historic district?
No, it was in Vienna.
Yeah.
Yeah.
And
So-
they're,
Just be careful how much you're willing to give
you
out.
never know who you're going to get with the engineers or the some of them are power players. They've been in the job for a long time, and they're they want to make sure that you know that you understand that nothing gets by them without their blessing. So depends. Yeah, depends.
All right, and then to answer your question, paragraph 7 of your listing agreement talks about optional seller-paid buyer broker compensation. So one of the topics of discussion with your seller is whether or not they would be interested or entertain paying a buyer agent who would come forth with a buyer for the property that you're selling. Now remember, you can't advertise this compensation anywhere in the MLS, so this would be something that if an agent called you and said, are you guys offering out buyer agent compensation, you would say yes, and then if you were going to disclose that number, that would be disclosable, right? And that would be with this additional form, which is probably microscopically small in your presentation, but it's the listing agreement addendum, optional buyer broker compensation, which outlines how much that seller is interested in paying out, and if they want you to tell other agents what that number is, right? So there's a lot of folks today that are listing agents today that are not disclosing these numbers, right? They're not telling us how much they're paying out. They're telling us that the seller is buyer agent friendly. Come in with your offer. So if that's the case and that's what your seller tells you to do, then you don't need this form, right? So you just gotta have your regular listing agreement. Whatever the number is that comes in with the offer, the seller decides whether they want to counter it, whether they want to go with it, or whatever they want to do with. So you may not need this form, but if they tell you, I want to pay X amount of percent out, and I want you to tell whoever calls you that's what we're paying, or they want you to advertise it on the sign in the lot, or anything in regards to that, then you would want to use this additional form.
Let me say that, as everybody knows, we've got all our jurisdictions, and we've got different standard forms, depending on the different Realtor Association publishers, and our different brokers, God bless them, are doing and have been doing their presentations on those standard forms, and those are in the nest as well. People like Tyler Simmons down in Richmond,
CVL MLS.
The CVR, Central Virginia Regional MLS, they have their own standardized forms. That's also where the Virginia Realtors Association is, the state association here. They have their own forms library, as most people know, but most of the people in Richmond proper use CVR MLS. So Tyler he's completely versed in all of that, and he teaches classes over in Maryland. We have Kara Norcutt, who's our principal broker for Maryland, and she does classes. Wendy Dean does classes. Noble Davis does G-Car DC. So different brokers on the different forms. The point is that these concepts are all the same, but the paperwork is a little bit different depending on where you're working. And thankfully, what I understand is that these different associations have been moving towards the middle to have consistency with the way they deal with these issues of compensation and unrepresented buyer compensation and all of that. But any further questions about that? This is the same language as the regular residential listing.
Well,
Back up to the listing compensation. Can you do that? Because there's a line in there that I don't understand. Because it says plus anyone who brings.
One more back.
I can't read this, and I can't
Okay.
see it on the.
Yep.
The first line on the listing, there it is.
Yeah.
Okay. So it says it'll pay the broker percentage, and then
Right.
it has a plus sign.
Yeah.
And then dollars, broker compensation, if during the agreement anyone, so that's not where.
No.
I'm confused by that line.
No, that's just your listing side, right?
Yeah.
So if you're charging, like we have some folks, right, because our policy says don't pad the $395 administrative brokerage fee, brokerage service fee, which there's a paragraph 6E is set up for your brokerage, your 6D, is set up for your listing broker service fee, which would be the $395 fee, right? So, but some folks have a team fee. So say I charge, my listing fee is 6%, plus I charge a fee of $795 for a team fee. So I would use that paragraph as 6% plus $795. So they would be on the hook for that, plus the $395 fee to Sampson down in the brokerage service fee. So this is just the listing side.
The point is, you
right?
can have a percentage plus a flat fee amount,
Right.
one or the other or both.
So next is the utilities major systems for the property. Here you're going to check what might be available on this particular parcel or parcels that you're looking at. And here, of course, we talked about earlier, you're going to want to try and research and see if it's not on the land, where is it? That way, because I guarantee you, when you list this property, one of the first 5 questions is going to be, how far away are utilities? So you're going to want to know these type of questions. Where's the electricity? Where is gas if it's in the neighborhood?
Sewer line,
if available. Water, how because they can calculate the cost in regards to how they're going to run that on the property. So make sure that you know where the location is on that, and of course, how do you find all this information out, right? Of course, sewer lines, you can go to the county.
Fairfax County is an example. They're so sophisticated because there's so much money. Loudoun County, Fairfax, for example, they have maps where you can go on and look by property address, or you can zoom in and see where all the public sewer lines are and where they end. It's pretty cool. And in some cases you might be looking at, well, it's not right up to your property. It's not running along your subject property, but it's one lot away. You might want to consider talking with your seller about talking with the next door neighbor about getting an easement across their property if it's not that far. That happens. In any event, if you have public utilities, it's mostly the sewer, but also public water, sewer tap fees, and these charges, that's a good thing to know. If public sewer and public water like I grew up in Vienna, we were on well and septic, right? We never had either sewer or water, but they did bring water in, finally, And so public water was available. We were on a well. We never wanted public water, but when I sold the property, I researched with Fairfax County, what does it cost to tie into Fairfax Water when it's right there? Obviously, sewer lines are more expensive, and if you got to go under a road, that's more expensive. But if sometimes it's the end of the sewer line is really only one lot away. It's not very far. So
Yeah. And they're down. I mean, I've seen them 12, 15 feet below the surface.
Right.
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 So expensive.
Natural gas, I'm not aware of gas line maps. In our market, was it Washington Gas, Columbia Gas, these different gas companies? On some of their websites, when it's working right, you're supposed to be able to go in and punch in an address, and they'll tell you if gas is currently serving that property or if it's on that street. Good thing to know is a little bit about propane too. When you're talking about utilities, try to, if you're marketing a property for a new home, particularly, and there's no natural gas, there's electric but no natural gas, find out what it would cost to put a propane tank in, because a lot of people prefer gas over electric.
Next part on going through this agreement would be what your brokerage duties are. This is pretty much similar. These are similar to the same duties that you would have in regards to any listing agreement. So I'm not really going to get too in detailed on this. Next one is your marketing, internet advertising. So if you're going to, how are you going to market this property, right? And that is what you have to determine. Now there's some notes on here that we have for marketing considerations. It's just saying, listing agent, do your homework before marketing. Surf the websites and visit the local county offices for zoning, map, land planning, development, environmental health, public works, mapping. You need to understand the highest and best use and know your county staff if they can provide you free and valuable service, right? There's a website here which we noted earlier for Land and Farm, but other resources out there, different websites that are available. Also, make sure you have good signage, right, for your property, right? Because you're going to get you could get a lot of passerby traffic, someone out looking in a certain area for properties.
Yeah, don't go cheap. Especially if it's acreage, depending on what kind of property it is, consider investing in a V sign that's like 8x4, 4x8 plywood times 2, like that. That's one example. Or just a straight, flat, but oversized, professionally installed. There's plenty of companies around here that will do custom signs. It costs money, and maybe you get your seller to pay for it. But you're not necessarily going to go with one typical post sign. I mean, if it's a one single lot, yeah. If it's an infill lot, sure. But if it's acreage,
yeah. Does anybody know? Does NV signs?
Yeah,
they do
they'll
them?
Yeah.
How about postmasters? Does Larry do that?
Yeah. Although he's retired. Larry from Postmasters been working.
Well, he sold his business. I don't know if he's retired or not.
Yeah.
But he's still working.
I mean, Yeah.
Well, theoretically.
No, I think so.
Mike retired too, but he's
right. No, the only one that's retired around here is Danny. Where's Danny? Come on. All right.
All right. We also talked about this earlier too, is joint marketing with local builders. So Mike kind of talked about that. Another marketing strategy that you might want to employ is tag teaming with a builder, presenting a home on that lot could net your seller potentially a higher value.
Or even if you don't team up with one specific builder, you could reach out to a number of builders and say, look, I got this piece of land. Do you want to make an offer on it, first of all, because that happens all the time. But also, if you've zeroed in on a couple of small or medium-sized builders in your area, and it could even be one of the big production builders because they do infill lot building, custom building. But you could get a packet of information with some, they'll be willing to come out and look at the lot and look at the measurements and evaluate the setback requirements, front, left, right, rear, to, give a really good solid idea of what's the maximum building envelope, what's the footprint, the square footage of the home max that could be built on that lot, and maybe provide you with some free information that you can have on hand with no commitment to that builder, but they're just doing it, speculating that it's another opportunity maybe to get a home buyer.
Yep. Back to the listing agreement, gets into whether or not the seller is authorizing the property to be placed in the MLS. Same check boxes that you have in all the other listing agreements. So whether or not you're going to do a coming soon, or it's going to go right on the MLS, I don't think normally you see that a lot with land in regards to coming soon, but it's an option if you need it. I also popped in this form, which is the MLS disclosure and residential seller landlord options page. So if you just remember that this is required by the MLS, Bright MLS requires this form to be signed by.
For residential.
Right.
Doesn't apply to commercial at all, or commercial land. I tried researching in Bright support pages whether that form is really required for a piece of residential land. It doesn't say that it's not applicable, so our position is yes, use it. Use it on all residential, improved or unimproved listings.
And then, so I just put it in there just so that you knew it was potentially needed for this type of transaction. Also, back to the agreement. Pretty much boilerplate stuff here from what is in your normal listing agreement. Any information with the seller is confidential. Authorization to disclose other offers if you receive multiple offers, whether or not the seller is allowing you, or whether or not they want to disclose that to other potential buyers. Compliance with fair housing, just making the property available to all. Whether or not it's part of a property owners association, or I don't know if it would be a condo association, but whether or not it be part of a property owners association.
Yeah.
You do see that on occasion where a residential lot will come up and it is part of a property owners association. So you may have to provide those documents in regards to the disclosure.
Real quick, Steve. A lot of times also there won't be a formal HOA. Many of you have experienced it perhaps with some of these estate communities where it's there's bylaws or covenants that run with the land. So ask your sellers. If it's like horse property, maybe there's trails or something, but look at the deed too. I mean, it's not what we normally do, spending time digging into covenants, restrictions, CCRs, the declaration from when the lots were originally developed and platted. But in those documents, sometimes there are certain restrictions that are not HOA restrictions, but they still apply, and I've seen it create some problems. Mostly just ask your seller on that stuff, and especially if there's any fee at all. If they pay, a lot of times these communities, they pay a very nominal fee each year, and but you need to know, your buyers need to know what they're paying that fee for.
Also talk to the seller about any current liens on the property, any taxes that might be owed, and fill this section out as best as possible, which is paragraph 17. Whether or not your seller is going to offer financing. Maybe they got a big bankroll in their pocket and they're willing to finance whatever buyer that might come forward. If they are, fill that out. How much they're willing to finance up to that amount. And then it does get into closing costs, who has to pay for what. Like I said, boilerplate language from our other listing agreements as well. whether or not the seller is characterized as FERPTA as per the IRS. Always is a very topic.
Right.
So make sure you check, and if the seller is not a green card holder or a U.S. citizen, there is the potential that FERPTA may apply, but it doesn't necessarily mean that it will apply, because there's a whole lot of exemptions and stuff like that in there. If you go to the IRS website, it will tell you what those are. And the best person to really figure that out, I hate to say it, is a settlement company. They'll make sure if they're notified. So when in doubt, you might want to check that they are not, if there's any question that they are not, and then you can figure it out later on. Seller's duties, whether or not they're a licensee, whether or not there's any abandoned tanks or anything on the property, make sure that you ask those questions. I would say if it's raw land, probably not got to worry about it. But if
there might have been a home in the past, learn a little bit about how these underground storage tanks are properly abandoned, what they call abandoned, filled with sand or filled with concrete versus removals. There's federal and state and county regs. So always ask if there's any tanks, gasoline tanks, fuel oil tanks, propane tanks in the ground.
There are a few definitions in paragraph 26 as well, which goes over what agency relationships are and what broker relationships are, so that there's everyone's fully on board with that. And then I'm kind of skipping along here because I want to get to the last page, but on the last page here, as we get to our thing, is a short list of recommended professional service providers, which Mike has put together in regards to, a lot of these are probably Fairfax or Northern Virginia type companies that could help in if your seller is going in a direction where they want to do some of this stuff. Here's some resources that might be able to help you through that journey.
Right.
Mike's also going to post this on Cardinal Nest under the Broker Resource tab. So you'll have this available and all the links will be active.
Yeah,
so
it's going to be this
you.
document, which is an outline, and it includes all of that with some other links. Listing and selling land, fundamentals, outline only, and then there'll be another package that has this with a lot of other stuff, like a real, as I showed you earlier, a feasibility study example, examples of boundary surveys, topo surveys, scope of work with breakout pricing by the engineer, an example of subdivision layouts, and a final approved Fairfax County record plat stamped and signed off by the Director of Land Development Services, and it also gets signed off by the county attorney and a Board of Supervisors member. That's when you do a subdivision. Hey, I don't know if Steve mentioned it, I can't remember, but I wanted to mention this too. This is I'm not sure if it's in the packet. A lot of agents are not familiar with the Bright MLS profile sheets. Okay, this one's for land profile sheets. If you log into Bright and on your dashboard, you go to the tab on the first landing page, listings, you'll get a drop-down menu, and there's a bunch of Bright forms there, including the standard Bright disclosure form, but also the different profile sheets. They have one for residential, improved. They have one for land. They got commercial. But I mention it because it's worth skimming through. It's a couple pages. These are data fields. These are all the available pick list data information fields that you as a listing agent have the opportunity to address and include when you enter a listing into MLS. And it's a good learning tool. A lot of things you might not have thought about when it comes to land, okay? So be aware of that. Again, this was limited mostly to the listing agreement and some of the issues relating to marketing and highest and best use, but all of that will be discussed further when we do a real in-depth session with the engineer to come up. So for those who want to learn more about the details with different kinds of considerations, come to that. Keep an eye out for that.
So that's pretty much it for today. Hopefully it was beneficial for you. And next week we'll talk about it from the buyer agent perspective. So you're sitting back, you get a call from someone that says, hey, I want you to show me this land, piece of property that's land. We'll kind of tackle it from that angle. And that'll be next.
A little bit on financing also next week probably, without going too deep. But there's a lot to learn for agents who haven't been involved in lot acquisition, financing, or lot acquisition, construction to permanent financing. Those are different loan programs that are available with different amounts of money down, but you got to have your ducks in a row. One closing can be done if it's typical residential deal where you're going to acquire the lot, you're going to have a construction loan with draws, and then the same lender is going to take it out. Once the home is built, occupancy permit is issued, they will put in place permanent financing, all with one closing. So good to know if you're working with buyers on land where they're going to construct stuff. So talk a little bit more about that.
Yep. All right. Well, thanks for coming.